Great. Thank you, everyone, for joining us today. As you know, my name is Pedro Pizano. I'm an attorney. I am the Assistant Director for the Democracy Programs at the McCain Institute, and we're very privileged to have with us today Dr. Gleb Bogush. He's a research fellow at the University of Copenhagen, and he focuses on international criminal law, ICL, the law on the use of force, IHL, or international human rights law and humanitarian law, IHL. He holds his Ph.D. from Moscow State University, and he has previously taught at the University of Luxembourg, Moscow State University, the Russian Academy of Justice, and the Max Planck Institute of Foreign and International Criminal Law. In June 2023, Dr. Bogush co-authored the Brussels Declaration, which condemns Russia's invasion of Ukraine and calls for the establishment of an international tribunal. So, Dr. Bogush, thanks so much again for being with us today. I'm happy to ask the first question, but if you want to say anything, please. Thanks again for being here.
Thank you for having me.
Great. So let's talk a little bit about the Brussels Declaration, and let's try to focus the conversation both as a message to Americans that may not have heard from Russians about what they feel about the annexation of Crimea that happened this Monday 10 years ago. Maybe we can even talk about Georgia in 2008. But also, let's talk a little bit at the same time about the intricacies of international criminal law, because I think by explaining those concepts and how they apply to individuals and those responsible, I think we can both make the case for our audience about why the Brussels Declaration was important, but also why this crime of aggression that we hear so much and has a long history both in the United States, both positively and negative, right, with Justice Jackson at Nuremberg and with the ICC and you know the whole story. So let's start, if you don't mind, with the Brussels Declaration. And I pulled it up and I encourage all our readers to read it. And I want to start at the very end, because I think you and your colleagues, and I'm so happy to see many of friends I recognize there, Vadim Prokhorov being one of them. You say at the end, this war became possible because previous grave crimes committed by Russia's leadership and military on its own soil and abroad went unpunished. So can you walk us through that chain of impunity, why it begins, how it's currently happening, and hopefully how it ends, or how we can, prosecute it and bring some healing and justice?
Yeah, certainly. It's the war of aggression against Ukraine that started in 2014 after occupation of Crimea and the intervention in Donbas region. Is not the first war that Russian regime and previously Soviet regime has waged against other sovereign countries. But we also try to pay attention to the link between violations of human rights, destruction of democracy, civil society, repressions, and many of these violations are also international crimes. And the war against Ukraine, the war of aggression. So we believe that there is a strong link between these two, sides of the Russian regime. And what is actually important is that this chain of impunity, how we call it, how we frame it, perpetuates, it reproduces the same patterns of behavior. And impunity, and all social scientists, criminologists know this very well. It's a very strong factor that facilitates the commission of the new crimes, the new violations of human rights, and that's what we see in case of Russia. So we believe that the only way to stop this chain of impunity is to work on the accountability and to create the real precedent of accountability, not only of the state leaders, but also of the people who are also convinced that they are immune from accountability. So it's our call for responsibility, but responsibility is after all individual. It's important to demonstrate that the crimes has names. You know, the crime has have names, and it's not possible after all to hide behind this abstract notions as states or groups. So this is important to start there. So strictly speaking, no single case of Russian official or military who have been really convicted, punished by not only by international courts but also by national courts take place. So we hope that it would stop.
Right, and no immunity, and we know the long history, and right now in this country, there's a big question about immunity. But in the international sphere, we remember the story of the Serbian leaders, right, and how they never thought, right? But also we must remember that the international community never even thought that it could be possible, right? They wrote that indictment of Milosevic and Mladic, and it took, I don't know, I counted once, it took like 10 years or 14 or 20 years, right? And so not for us to lose hope and keep that hope alive that one day those responsible for these grave atrocity crimes will be held accountable. So can you take us a little bit into the distinctions and the history, maybe all the way back to Nuremberg, and reminding people of the US's role at Nuremberg, but also Nuremberg was mostly about aggression, right? We remember Nuremberg for a different reason. But the tribunal, the case itself was about aggression, and Justice Jackson, if I remember correctly, left the Supreme Court of the United States to go prosecute the crime of aggression in Nuremberg. So just for the general public, aggression, crimes against humanity, war crimes, and then let's talk a little bit about the history and the special tribunal that and why we need a special tribunal specifically, which is important.
So you're right. All roads lead to Nuremberg, where there was the first instance of the criminal responsibility under international law. So for the first time, the leaders of state, in this case Nazi Germany, have been tried and convicted, most of them, for international crimes defined by international law. So it was really the important precedence, and the road to this precedent was paved by allied nations, the Justice Jackson you mentioned, but it's less known fact that the person behind the aggression charge, and at that time it was called crime against peace. Right. And it's exactly was the case of Hitler Germany aggression, which was in the heart of all the crimes. So even the most horrific atrocities, including Holocaust, was related to war. So it was the clear understanding that the aggression was the central charge. Was the Soviet lawyer Aron Traini. So it was he is of Jewish origin. He came from the city of Vitebsk, which is now in Belarus, and he was professor in Moscow State University, the same university I was educated in. And the interesting that it was his critical contribution that also demonstrates that it's not a Western plot. It's not just invention of the United States or UK or whatever. It was really universal attempt to formulate this important provisions of international criminal law. And yes, the Nuremberg was recognized the centrality of aggression, and the idea that was reflected in the judgment, that it is a war of aggression that actually not just facilitates, but actually caused all other evils of war. So if I quote the judgment correctly, I hope it's called that, it said, the tribunal said that the aggression is different from other crimes. It's just that it accumulates the evil of the whole of war. And quite importantly, we have the same in the case of Ukraine. And it's not that aggression always a central thing. Horrific crimes, genocide, crimes against humanity, war crimes are committed on a large scale in a situation that don't include aggression, that don't include this interstate use of force. But Ukraine is precisely the case. So I just recall that a lot of Ukrainians, millions of Ukrainians, have to leave their homes. They have been displaced by the war. Environmental damage. It's even impossible at that stage to assess, but it's of colossal scale. It's really take alone the destruction of the Kakhovka Dam. It's a lot of long-term, serious, severe damage to natural environment. A lot of people have become victims of incidental damage caused by the attacks that presumably have been directed at military objectives, but they have been collateral damage. This is very well-known way to formulate human tragedy in this legalistic way by incidental damage. All these people mostly cannot claim that they are victims of war crimes and crimes against humanity, but they are certainly victims of the crime of aggression. And most importantly, it's about soldiers' lives. Imagine a Ukrainian soldier who is defending their country from the war of aggression. They are in self-defense, and unfortunately, they're killed in the massive numbers. From the international humanitarian point of view, they are legitimate targets. It's legal to kill them. Unfortunately, but at the same time, why they were killed? They were killed by illegal war, by the criminal war. So it's not just illegal. It's a criminal. It satisfied the full elements of the crime of aggression, which was defined finally by the Kampala Agreement, the Kampala Amendments in the Statute of the International Criminal Court. So to make the story short, it's not about that aggression is always worse than all other international crimes. But it's the case that without addressing aggression, in this particular case, the international law fails, and the victims' expectations would be betrayed. So that's very important, not to let this unpunished. And it's a kind of Nuremberg promise. And actually, it was precisely promised by the nations. I recall the words of Justice Jackson. He said that we set up standards upon which we should behave in the future. So it should be our responsibility because we set up today rules for ourselves, for those nations which set up this tribunal. And this is a moment when these promises should be fulfilled. Why we have this situation in Ukraine? Why we don't have other ways than to set up the special tribunal? It's because the International Criminal Court that in principle has jurisdiction in Ukraine because of the acceptance declaration, the ad hoc declaration submitted by Ukraine in 2014 and 2015. But for the reason of these Kampala amendments, they also set up the scheme upon which the court can only exercise jurisdiction when the states, not just aggressor state, but also victim of aggression, are members of the court, the state parties to the Rome Statute. And this is not the case of Russia and Ukraine. So basically, the state has no incentive to become a part of the court because in other ways it can be prosecuted one day. So this is a very unfortunate provision. By the way, now it's a lot of discussions among states to change this, but this is the situation right now. So International Criminal Court that would most, it would be most straightforward way to prosecute the crime of aggression is not available. The trials on the national level has obvious deficiencies and generally not considered to be a proper response to the crime of aggression, because it's an interstate use of force. It's also the question of immunities of state officials. Traditionally, immunities apply on the interstate level. So we certainly need international institution, and such international institution was proposed just in the first days after the full-scale invasion. It was proposed by several legal experts, including Professor Philip Sands, British lawyer and very well-known writer on accountability issues and the history of international criminal justice. But now it's initiative that's strongly supported by Ukraine itself and a number of states, mostly European states. But yes, you are right. United States is not very enthusiastic about that, and it's not among supporters of the Special Tribunal, unfortunately. It's also a problem with the International Criminal Court because the current prosecutor is not has a kind of skepticism about this initiative. However, its initiative is still living. It's still negotiations. There are negotiations about the tribunal and the model that this tribunal could take form of. But it's also what I would like to bring your attention to. It's clearly scholarly consensus, So it's scholars and specialists and experts are, I think, overwhelmingly support this initiative. And this is also an initiative that we, a group of Russian lawyers, strongly support. And it's a part of our Brussels declaration that we started with, because we believe that it's not just the viable support of Ukraine. We support Ukrainian initiative not because we just blindly support everything that Ukrainian authorities say, but because it's a right approach. It's a correct focus right now. And without addressing the crime of aggression, it would not be possible to move further. We believe that crime of aggression is central. We believe that individual responsibility should follow, and it is the way to set up correct, verified historical record. It would give chance to reconciliation in the future in the region. It's the precondition for peace, in our view, to let this aggression to be unpunished. So, Special Tribunal initiative has its a lot of merits, but most importantly, it really addressed the central issue. And this issue is human suffering, victims, and violation of the most fundamental rule of interstate relations, the use of force, the prohibition of the use of force.
Yeah, no, that's exactly right. I was just rereading about Ona Hathaway's book, The Internationalists, right, about how the Kellogg-Briand Pact really predates the UN Charter, which prohibits the use of force. And I just wanted to mention that because she's one of the legal experts who is in favor of a tribunal, and they wrote a great 4-part series, I think, at Just Security about it, including one by David Sheffer, which I found fascinating. And the last scholarly reference I'll make for our audience is the one you mentioned. I just can't recommend it more highly. It's one of the best books I've read. East West by Philip Sands is just a marvelous piece of nonfiction writing about everything that is, for a lawyer, it's incredible. So I highly recommend it. And I wanted to come back to 2 things. First, as Philip Sands shows in that book, that little town of Lemberg, Lvov, right, which is in today's Ukraine, is in some parts where modern international criminal law was sort of born, right? His argument is that in one street, both Lemberg and Lemkin and his grandfather, if I remember correctly, lived at some point in time. But I wanted to make reference again to that first point you made about how the aggression idea came from a Soviet lawyer, and it had all kinds of historical reasons, but making the point, one, that it was born out of an empire, right? It was the Soviet Union, that in the United States, one of the reasons why this country, and that's why I mentioned David Sheffer, because he led the negotiations for the Rome Statute. But this country, after the bombing of Kosovo and then the invasion of Iraq and Afghanistan, right? There's still a scholarly debate about how, preemptive wars or Obama's Nobel Prize speech about a just war or preemptive self-defense align or would be impacted by an aggression, right? There's still this idea that it should not, that the big powers, like one of the ways that people have put it is that the big powers will never agree to it because they want the right to preemptively self-defend, right? Russia, China, France, the five permanent members of the Security Council. So if we could come back to one, the idea of that this was a Soviet idea, two, that it's yourself coming from Russia and calling for this, which would impact your own country. But also like the modern history of aggression, right? Why we have come to this point, and is it part and parcel of international relations, Peace of Westphalia all the way up to Nuremberg, or is there a different way, as told by Ona Hathaway and Scott Shapiro in the book The Internationalists, and Caleb Bryant and Samuel Levinson in Chicago? How do we think about all those things?
Yes, it's no doubt that it's not the only illegal use of force. Unfortunately, this is the feature of current international relations, that force continues to be used and very often used illegally. And we have other international ongoing conflicts where this issue is also kind of central, And the problem is also that the system is not perfect. We don't have international court with jurisdiction over all these situations. The jurisdiction of the ICJ, for example, International Court of Justice, principal organ of the United Nations, is based on consent. So it caused situation in which the court, in most cases, almost in all cases, can only address the issue of the use of force through different legal instruments, and it's always the issue that states try to protect from from the court, not they don't allow the court to touch this issues of state use of force. So we have to deal with the system which is not perfect. We have this like George Orwell would say, more than equal. Some states are more than equal in the system, which is based on equality of member states. We have privileged countries which are still the winners in the Second World War. It's after 80 years we have the same beneficiaries from the system. And it's of course it's a key issue where unfortunately all these permanent members are united. They protect their privilege. They believe that they have some more rights than others, including in the situation of so-called preventive self-defense or preventive wars. And yes, Putin heavily abused this practice. It's he relies on the NATO action in 1999 against Yugoslavia. He relied on the Kosovo precedent. He relied on the Iraq war heavily. And of course, I mean, of course, just to be clear, I believe that at least both Yugoslavia and Iraq have been illegal differently, but there was not a good precedent. It did not bring us good law, good examples to follow. But yes, this always a question of double standards, and then this is a feature of international relations, unfortunately. But this is a question what the lawyers should, what the legal experts, what the legal community should recommend. We can just set up. We have to just to be open. What the rules of international law say. What is the proper way of behavior, and what kind of consequences the war brings to us. It was demonstrated also by Iraq war that the war itself, it produces the consequences that cannot be controlled. It produces in all cases the atrocity crimes against humanity, war crimes. They always have to be committed. So it's an idea that so many American lawyers have dedicated themselves. So I just recall the great example by Benjamin Ferencz, the last the longest lived prosecutor in Nuremberg in the one of the trials that US had in Nuremberg against so-called Einsatzgruppen, the killing squads of the Nazi Germany, of SS, who actually operated in Ukraine. So this is more including the massacres against Jews and others. That's that Benjamin Ferencz was actually dedicated his life to the idea of the justice for the crime of aggression, because he being himself, soldier and later prosecutor, he understood that it is the war that also caused these atrocities. It was the war that allowed these atrocities to happen. So it's no one single question to answer, because I think it's of course the responsibility of all peoples to take all possible measures to prevent the wars. However, it's important. It's important responsibility also of the nation. So I'm, for example, not thinking that I'm personally, responsible for the specific use of force or crime of aggression, not think about atrocity crimes, but we as, I'm as Russian lawyer, like Russian legal expert, of course, have moral responsibility to contribute to understanding. And it's also important to speak to American public for the simple reason that in US, in the United States, there is a freedom of speech, and there is a space where we still, hopefully it would be the case in the future, can express our opinions, have to share and influence the public by telling them the truth. One of these truths is that international law prohibits the aggression. It prohibits the illegal use of force. It prohibits the crimes defined by international law. And the same approach should apply not just to Russian leadership, but it should apply to all other state officials who commit international crimes and who initiated and wage the wars of aggression. This is the law. This is so we should not confuse the legal rules and the way they are implemented. There are very often the situation in all areas of law of law. So take criminal law. The most crimes, unfortunately, remain unpunished. But we don't talk about criminal law as non-important or non-efficient. It's still very important because it tells people basically what is right and what is wrong. And the same approach should be applied, of course, to international criminal law. And happily, we have not just Nuremberg now. We have the story of Yugoslav Tribunal you mentioned. We have the story of Tribunal for Rwanda. We have the Special Court for Sierra Leone, when the dictator of Liberia, Charles Taylor, was punished after the long trial. And we have many other examples. And I hope that these examples would be complemented by the prosecutions, real prosecutions, not just announcements and arrest warrants, but real prosecutions by the persons who committed the crime against in the war against Ukraine. So I think it's a huge work to be done, but most importantly, not to forget about those rules and not to forget about our objective.
Amen. I couldn't have said it better. Thank you for those very powerful words. There's also Cambodia, and I wanted to ask you about how you envision an international tribunal to prosecute the crime of aggression. I think one of the, there's many, right? I think one of the acronyms they've come up with is STCOA, the Special Tribunal for the Crime of Aggression. And there's all these ideas about whether it be hybrid or international or non-international. Do you have any ideas of how to move that discussion forward and why it's important for the legal nerd in me, and that we could move quickly away from the legalistic nature of this by talking a little bit about that, but also how it relates to what I've counted. I think it's 4 arrest warrants by the ICC against Russian officials, and what they mean, because you start to talk to us about what this means for people on the ground, right? And one of the arrest warrants for Putin himself is for the abduction of children, right? So if we can talk a little bit about the nature of the tribunal, again, what we're trying to remedy here, and then we talked a little before about like the uses of international justice, right? So we talked about the historical record, breaking the cycle, individual responsibility. You said precondition of peace. How do we, if state it one more time, why this is important, right? Because I don't think that in this country or in the international field or legal field, like we don't come back to the suffering that you were just trying to relay and you express so powerfully, right? It's people suffering and we need redress and we need justice. And if we don't get it, if we don't stand firm about prosecuting this crime, as Jesus said, the cycle will continue, right? There will be more suffering and people who have suffered will find no justice.
Like, let me say a few things first on the tribunal model. So just to explain the public about what is discussion now about. So to make the story short, every participants, discussion, because it's a discussion about among states, but there is of course legal experts and diplomats who are actually taking part in negotiations. There is no voice that said that, well, aggression should not be prosecuted. There is no such thing. There is no such voices. But when it comes to details, what kind of tribunal we want and what kind of mechanism we want, there is, of course, a huge division. So there are two major schools of thought about that. So first is the International Tribunal. So creation of International Tribunal that would be created by international treaty. It's a classic way to create tribunals. Nuremberg actually was created this way, but with, of course, with involvement of the United Nations. This is a leading scenario that resolution of the General Assembly, it's not, of course, binding, but it's has effect within the United Nations system, and it shows also the endorsement by states of this initiative, and it paved the way to the conclusion of the treaty. So the key difference of International Tribunal that it would not be part of judicial system of specific state, especially Ukrainian state, but it also would be possible to prosecute officials regardless of the immunity, because immunity still operates on the interstate level. It's no doubt about that. But international tribunals, there is a practice. There are precedents based in different courts, like Yugoslav Tribunal, like that tried Milosevic, for example. We had the Special Court for Sierra Leone that was not established by Security Council, but it still had to prosecuted Charles Taylor, who was during the time of the arrest warrant, he was a incumbent president of Liberia. So we had some precedent, and we have also case of in the ICC, which is also treaty-based court. And al-Bashir is still, unfortunately, he's not still in The Hague, but at least we have the arrest warrant and we have the jurisprudence that confirm that rule that there is no immunity before international courts. And this is a key thing. The alternative suggestion that supported by the United States, by the way, the ambassador at large, Batman Shak, expressed this publicly, and there is also I think supported by also by Germany and some other states, and it was reflected in the G7 statement, is the so-called internationalized or hybrid tribunal. So the difference that this type of institution would be part of the judicial system of Ukraine. It would be based or rooted in the Ukrainian system, but it would have some international support. So then it's not so much details, it's very vague what kind of support this tribunal has. But the problem, there are many problems. Some of them are legal, because, for example, it requires the changing of Ukrainian constitution, which is not now realistic. It's because the constitution of Ukraine prohibits the special courts, extraordinary courts, and it also doesn't allow international judges, for example, because it requires that the judges should be Ukrainian citizens. But there are more problems when it comes to immunity issue, and of course, the general perception of such tribunal. So it's two very different things. One thing is when it's international efforts and international trial of the crime of aggression. And the very different thing is when the state, victim state, judge the leaders of other states. And potential effect, for example, when we think in real terms about, for example, effect of arrest warrant of these two tribunals would be very different. So that is the two major suggestions. But of course, there is much more ideas circulating right now in this debate. But to my position as well as position of majority is that, of course, there is a strong preference in favor of international tribunals. However, and yes, we don't expect realistically that this tribunal will be created tomorrow and start working immediately. The idea that we have this aggression and focus, and such institution would be created. This is most important. So second, it's about the ICC arrest warrants and what is currently happening. Yes, the ICC is a tribunal, the only international tribunal that has jurisdiction over Ukraine. All crimes committed in the territory of Ukraine, regardless nationality of the perpetrators, and 3 categories of international crimes. And yes, it's a lot to prosecute there. It's a lot to investigate there. We have now information. So I would like to correct a bit this. We have just publicly available information about 4 arrest warrants. The problem that we have not seen these warrants, we have not read these warrants. We have very little to say about the evidence that prosecutor relies on. And this is, I think, it's becoming already a controversial approach, because on the one hand, yes, it's important to give the signal, the message about the things that prosecutor is investigating. However, I don't think that we don't know anything about Vladimir Putin, for example. We are familiar with this man. Even I think our public is very well aware of what he did. And the secrecy of this warrant, I don't think it's much more question than answers right now. So why we need to keep it like that? And the questions, I think, has to be started to ask the prosecutor about what is happening and what would be maybe real cases. Because all these 4 warrants, so it's first warrant, you're right, was about abduction of children, but there is 2 other warrants that was recently in the same way. They were issued in the same way. So they are still under seal against two commanders of Russian army, Russian armed forces. The charge there, it's much more, legally diverse, because it's not only war crimes, but also crimes against humanity. It's important precedent, by the way. They are related to the attacks on critical civilian infrastructure of Ukraine. So this was the mostly missile attacks and the use of the weapons and so-called incidental attacks. So the situation in which by targeting military objective, there would be unproportionate civilian harm. What I mean by real cases. So I see the prosecutor, I think it would be a good idea in this investigation was to start with the maybe small fishes, not just with the top leaders who are in Russia. They are unavailable currently. It's important to give them a message, but I think maybe more important would be to have the real trial one day at least. And currently, for example, there are some individuals who are in the countries, in the Rome Statute parties. So I just recall one case. It's a case of so-called Petrovsky. His name is, he also has Norwegian name. And this guy was accused of committing crimes in Donbass in 2015. It's the court has jurisdiction. His extradition to Ukraine was denied, and he's now in Finland, in Finnish custody. And this is one example, one potential case and I believe there are more such cases when some individuals, I'm not sure, I mean, maybe he did not commit these crimes and he could be acquitted, but at least I think it's a real way to start the real trials. And I think it's maybe good expectations from this investigation, because if we have just a few warrants of arrest against people who are currently unavailable, that's not probably very promising. And I think it's legitimate to ask these questions, especially because of such international support. I recall that states even made voluntary contributions to the court budget specifically for this investigation. So it's not just moral investment, but it's also material investment. And I think the court should provide, even in such difficult case, value for money. This is what we expect. And but it's also, I think, should be support to the court mission. Doesn't always mean that we have to just to praise what prosecutor is doing, but it's also important to support the institution and to support the idea of investigation. So I think the ICC, of course, is crucial. And anyway, I think it was a very good beginning, right decision to start with the abduction of children. It's one of the very important priorities for the prosecutor. So let's continue that, and let's wait. Maybe we will have more information, more news from International Criminal Court.
Thank you. Yeah, agreed. It's important to balance that need for prosecution and long-term deterrence. At the same time, the whole idea of how much these tribunal costs, right? The ECCC in Cambodia, billions of dollars, very few defendants, and how and why they're important, not regardless of the money, but how to spend that money. So thank you. I know we have very few minutes left, so I wanted to ask you some very last final questions. You can choose. One about technology and the use of technology to investigate war crimes, crimes against humanity, genocide, and the crime of aggression, and also command responsibility, because usually or sometimes in international law, it is more linked to the commander and how you prove that is the difficult part rather than the crime itself. or I wanted to talk about something completely different, and I'm sorry we don't have time, which is the illegitimacy of Putin's regime. At which point and how in international law, if you know or can point us to, how can one declare a ruler illegitimate, right? It's his 5th term. He just won the election, as everyone expected. His coronation, in quotation, is May 7th. I've done a little bit of research, and it seems that the 2000 election could have been free but not fair, or fair but not free. But really, in all of Russia's history, there has never been a free and fair election. So how does one think about Putin's 5th term all the way to 2030? How does one declare it illegal? What consequences would that have? So I'm thinking of Gaddafi and what happened when Gaddafi in Libya was declared because he started calling for his own people to be, if I remember, it was not cockroaches because that was Rwanda, but rats, or I will kill them. There was some genocidal statement attributed to Gaddafi, and Obama said, we don't no longer recognize you as a leader, and then, no fly zone, and the very unfortunate extrajudicial murder of Gaddafi happened. But so either technology, easy or maybe difficult question about technology and command responsibility, or if you have a few minutes to talk to us about Putin and his 5th or 4th re-election, I guess.
Yes, we see already the huge potential of the technology in investigating war crimes, and I think it's international crimes, all international crimes, and we have a lot of examples in Ukraine. So just even in official investigations, so the press reporting, investigative journalists, they did enormous job. So I just recall the New York Times, for example, investigation on Bucha massacre. It's really something that we see, and of course the prosecutors, international prosecutors, and the state prosecutors use now. It's more important. So I think it's enormous potential, and this is something that is not counted well by the perpetrators. So I think it would be a lot of surprises when we come closer to the trial. So I hope the most important to reach the stage, and we see, I think, much more information about that comes from these sources. About Putin's, I think there were one election in Russia that could be seen as free and fair, but it's unfortunately the early 90s. Just the first probably election by President Yeltsin. I remember. I think it was closer to what can be described as free election. But it's true, Putin never have been elected on a free and fair election. He never participated in, so I would like to say Americans, for example, that he never participated in debates with the opponents, never. No single case that he met an opponent in open discussion. So that's the guy who claimed to be great politician, that's not true. And of course the turning to the legal point, if Russia claimed to be democratic state, of course it never can be accepted as legitimate elected leader. Not only because of elections themselves, the deficiencies of election. Of course, the constitution clearly prohibits one person to be in power forever. He manipulated the provision that was not written very clearly about consecutive terms. So it was, but it was a general understanding that already at that time that it was at least incorrect interpretation of the constitution. He didn't have a right to be elected in 2012. But also what is important and what should be, I think, also seen that now up to 9 million of Russian, just imagine the figure, are deprived by the passive electoral rights. So it started with the small things. So for example, currently, the very well-known political prisoner, Vladimir Kara-Murza, he was victim one of the first such regulation because of his dual citizenship. He cannot, even theoretically, now be elected, not just to presidency, but any other public elected post. Alexei Navalny, who tried to participate in the previous elections, could not do this because of another prohibition that was imposed. And now it's more and more such laws, and yes, it's millions of people who cannot participate in the election itself. There are many more reasons to see that it's not a proper election. This procedure that we had a few days ago shouldn't be even called elections. I think it's the biggest mistake to analyze, figures. And we could see that even in these elections, the regime has to resort to very primitive electoral fraud, just very old technologies. So even these things happening. So from this point of view, if we consider democracy to be applicable, to Russia, it's of course not a legitimate election. However, it's no such thing as states have the procedure to recognize every election, every leader as legitimate or illegitimate. It happens very rarely, and states generally avoid explicit recognition of the governments, because it's considered to be still an internal matter. There is also, very unfortunately, no rule that democracy should be the system, every country. So that makes this case much more difficult, because we are talking about the country at war. We are talking about the country with the nuclear arsenal and many other things. I still believe that it is the politicians around the world still have, I think, they overestimate, I think, the consequences of such statement. But I think the language that is now used is not very helpful. I think it should be much more clear rejection of what is happening, and consequences can be very different. But most obvious consequence of non-recognition, that it's also non-recognition of immunity and privileges of the head of state. It's, I think, important, even from political and moral point of view, that because this immunity that Putin so likes to use, to protect him from any kind, even talk of responsibility. So imagine Russian investigative authorities open the criminal case against the judges of the International Criminal Court. And the charges there is that they, by non-respecting immunity of Putin, they somehow, committing attempt to attack him. It's a very bogus charges. But anyway, it's very important to provide him this feel of legitimacy, because he's not legitimate. But yes, in the current context, it's very hard to expect that it would be many states which explicitly say that. But I think it's an important topic. It's not we should not stop talking about that, because it's exactly what I think Putin wants, and he relies on this. He should stop, abusing this recognition, because it's actually what states can do. They cannot do many other things, but this is what many states can do. They can say, well, we don't reject that. We should stop playing this game and pretend that he's just elected leader. And I think from moral point of view, it's very important. So Russians, many Russians feel betrayed, because there was a specific calls also to United States, but not only, to world leaders from political prisoners. I just recall Vladimir Kara-Murza, who wrote this post in this op-ed in Washington Post from prison, and there is a very specific call not to recognize Putin as legitimate president. And I just would also say that sometimes it's very easy to refrain from doing something. It's much easier to do than to make a formal declaration. It's just stop recognizing him. And I think it's very important because that also empowers people in Russia. And I remember, for example, this arrest warrant that we just discussed. That was a very, it was very empowering because yes, at least there is some hope and there is some signal that the international community is thinking of the victims, not just about Ukrainians, but also about Russians. And we now have I think I'm afraid that we're missing another opportunity to remind this regime that accountability exists and that democracy is not just privilege of some countries. It should be rule for the whole world. And human rights do exist for all nations, for all people of all nationalities. I think it's very important, and I think it's a key to win this country and to bring it back to international community. I think it's in everyone's interest to have not just free Russia, but also democratic Russia.
Thank you. That was as thoughtful and strategic and deep as we expected. Thank you so much, Dr. Gleb Bogush, here today with us at the McCain Institute. It has been a pleasure chatting with you for this past hour or so. We really appreciate you being here. We really appreciate your comments. Please count on us to help you and your friends for exactly that. Thank you again for being here for Free Russia, for Free Peoples, Dr. Gleb Bogush at the McCain Institute. Thank you so much.
Thank you very much. It was a pleasure.
Thank you.